Hi, hello everybody. Welcome to BWF Solicitors platform. This afternoon on the Community and the Law show, we've been discussing a very, very important topic, and we thought it's best to sum it all up in English for all of us who are not really conversant with the Akan language. So we've been discussing retention of right. We've been discussing retention of right under the EU law. So the 2016 regulation and the EU regulations, which is basically couched from the Directive 2034 law of the EU, it's transposed into UK domestic immigration law. And that's where we have the retention right. So we've been discussing the basis on which you can retain your right if you're an EEA family member who has ceased to be a family member. So we've mentioned that, for instance, if you lost your partner or your partner died before you attained settled status or permanent residence, which is what was known back then before the EUSS or the Appendix EU came into being, then you could make an application to retain your right. So what you're showing is that indeed you were a family member, you were married, you were married, and then prior to your husband or your spouse passing away, you had lived together for 1 year immediately before the death happened. You could retain your right by providing your the death certificate and your marriage certificate and other documents which shows that indeed you were together as a family. Now, the other thing is that just in case you were married and your relationship is come to an end, so you've had a divorce or you were in a civil partnership and so you've had a dissolution of that partnership. Again, we said you could retain your right on the basis that you were married to this person and that marriage is come to an end, or that civil partnership is come to an end. What the law asks you, for you to be able to obtain that retention of right, is that you provide evidence which shows that you had married this EU national for a 3 years period, and then you had lived in the UK together for a year. So if you had done that, then the law says, yes, you could retain your right. What you could do is make an application under now the EUSS and retain your right. If you're not done your first 5 years, what you would get is another 5 years. And then after that, you'd be able to apply for your settled status. As I explained, you do not need to wait for all of the 5 years to elapse to apply for your settled status. You can apply for your settled status once you've topped up all of your years, counting from when you first married up to the time when you made your retention of right. If you can count from that and it comes up to more than 5 years, you'll be able to apply to settle here in the UK. The other people that can also apply to retain their rights are people who have been through domestic abuse. So if you've gone through domestic abuse and for that reason you've left your marriage or you've dissolved your marriage or you've divorced, then you could apply to retain your right. Interestingly, since June 2020, the law is being extended to other family members. So as at 2016 April or thereabout, the law only applied to people who were spouses. Now, it extends to family members as well. So if you're a family member and your EEA family member upon whom you depended to come here is left their marriage, you could also apply under the domestic violence rules to retain your rights. Again, we've mentioned people whose parents were EU nationals, had lived here with them, and they all of a sudden have left to go back to their home country. And so they've left the child here, and the child is in school. that child can also apply to retain their right here in the UK. And then there are people who had children with EU nationals, and they are looking after these kids in the UK. So they are taking care of these children in the UK. You can also rely on the children to make an application to retain your right. All in all, there's a basis for you to make an application if indeed you meet all of these requirements. It is very, very, very simple. You don't have to, as at before, provide a lot of things. So you could do that under the EU settlement scheme, which basically assess your application based on residency now. If you can provide all of these things, you are able to make an application under the EU settlement scheme to retain your right. And once your marriage is lasted for over 5 years, you can apply to obtain EUSS settled status or indefinite leave to remain. So basically, this is what we've been discussing. If there's anything that you did not catch, by all means, please give us a call at BWF Solicitors. Telephone number 0208-493-7340. 0208-493-7340. Better still, if you want to come and visit us in the office, we're at 7 Sisters, 4th floor, Anna House, 214 to 218, 7 Sisters High Road. The postcode is N15, N15 4NP. So postcode N15 4NP. And if you're coming by train, you want the Victoria line, which comes straight through to 7 Sisters Underground Station. You need the exit number 2, and we'll be there on the 4th floor of the Anna House. It's a tall building. You wouldn't miss it at all. Thank you very much for keeping us company. Thank you very much for listening. We'll come your way again same time next week with yet another beautiful discussion on UK immigration law. Thank you.